SJC-13727, Commonwealth versus Nathaniel Rodriguez.
Attorney Dahlberg.
Good morning, and may it please the court. I'm Nancy Dahlberg on behalf of Nathaniel Rodriguez. This appeal presents two issues of potential significance to many of our cases, and I'd like to address both of them, starting with the discriminatory use by the Lowell Police of Snapchat surveillance. Excuse me. We're asking the court to allow Mr. Rodriguez's motion to suppress on equal protection grounds. The totality of the circumstances show that Mr. Rodriguez's Snapchat account was monitored at least in part because the officer employed an investigatory scheme targeting people who were not white. That is enough to establish a reasonable inference that was not rebutted by the Commonwealth that race was a motivating factor in that scheme.
Can I ask you a specific question about the group that was looked at? Mm-hmm. So if he's building his friend network using people that are otherwise friends with people in the gang unit, and I know there was a defense request for identities that was denied. Mm-hmm. Are we to assume, or can we assume, that the pool of people that were in that friend group were also people of color? How do we get there? I don't see it from the findings, and is it a remand for that purpose?
I don't think a remand would be necessary or warranted here because I think the evidence is what it is. The Commonwealth provided nothing in rebuttal, but to answer your question, Your Honor, I think the fact that, an inference might be drawn based on this officer's testimony that the places that they were driving around might have been inhabited by people of color. He used he said variety of cultures, but that's really more of a support for the strongest inference here, which is that this officer went out of his way to create a profile that was non-white. He created a cartoon image, a racialized cartoon image, and he chose a profile name that was non-white. We don't know what these are, they're not in the record, but he didn't have to use a Bitmoji, he didn't have to have any profile photograph, and there is no reason to have created a username that was non-white. So that's the primary issue here, and that's why the judge's decision that there wasn't evidence that the officer knew at the time what the race or ethnicity was of the owner of this account is not dispositive.
Don't we require more specificity than non-white? The categories are, we don't lump non-whites into a discriminatory category, do we?
So, Your Honor, the reason that what's in this record is non-white was the Commonwealth's
I know
doing
that's
along
why
with
they
the judge.
used it, but don't we require more particularity? That's not a discriminatory category, non-white, is it?
Well, I think the exclusion of whites from a category is discrimination under the Equal Protection Clause. In addition, Smith versus Commonwealth and people in...
Your client's not white.
Not white, yes, Your Honor.
He doesn't have standing to bring a claim on behalf
Well,
of white people.
there are cases, the amicus briefs are really excellent, and there are a number of cases cited, but either whether this excludes whites, and there are a number of cases that establish that, or whether this is a Smith versus Commonwealth situation that simply embraces this distinction as a violation of equal protection is somewhat aside from the point that the fact is that the Commonwealth can't refuse to provide information and be supported by a judge and then use that as a way to immunize itself from challenges under equal protection grounds. We have this record because of the Commonwealth and the court.
Are you, sorry.
No, please, go ahead.
Are you arguing that the use of a non-white Bitmoji and or a non-white username per se meets a defendant's burden at the first step to establish a equal protection violation?
I would say that it does here, and that's one aspect. The other aspect is that there was no...
Has anyone ever held that it's per se? Wouldn't you need some additional information to know whether the use of a particular kind of Bitmoji and username. What I'm worried about, frankly, is any kind of undercover work where an officer tries to blend in with surroundings, let's just say.
So in this particular case, the officer was not, there was no suspicion of criminal activity that caused him to friend any particular person. So he was creating a street corner made up of non-white people on the internet. And not only, of course, I know the course is very aware that the kinds of things that can occur through digital surveillance are broad and intimate of the users. So that's one aspect. But there's, I don't, you know, there isn't very much in this area because this is new. And the police.
What I'm
using
trying
these
to
fictitious-
find out is, what if you had a hypothetical that you're in a non-white, let's say real 3D world, regular world area, that's residential and not made up primarily of white people, and you're trying to do some kind of undercover surveillance of what's going on. I'm trying to figure out why the police couldn't dress the way that's consistent with the neighborhood and the environment. Do they have to dress in a three-piece business suit?
No, I'd be happy to answer your question. The fact that there's an existing community and that an officer is there to blend in, which is ordinarily in our experience based on some suspicion of criminal activity, but let's just say they're there for another reason. Long itself indicated that, you know, over-policing or constant policing of a particular neighborhood in deference to others is also not allowed. This is akin to that because the officer created his own neighborhood. He reached out, he created a profile that was going to attract others, just as the court said in Dilworth. You know, these representations and names mean something, and there's a reason they're created.
So if we knew that the names he reached out to were all people about whom the police had some information of gang activity, would that be enough?
Well, that's one thing, but you know, in Dilworth, there was some suspicion of gang activity. The question is, were they just looking at black people who they had suspicion of gang activity or not? And the court there this court, of course, indicated that these representations are persuasive and meant to attract people. The fact that here we have non-white characterization and no suspicion of criminal activity can only mean that the officer intended, or the inference has to be raised. And of course, this court in Long and its progeny has created a situation in which people can make these challenges, should be able to make these challenges, and the Commonwealth has to rebut them. And you know, the Lowell Police Department does not keep data. They do not have rules and regulations. This really is a situation in which these intentions can run amok, and I think here they did.
Counsel, can I follow up with that?
Yes.
Because you're talking about the raising of the inference, and when you started off, you said that we should allow the motion to suppress, and I believe you also answered to Justice Gaziano that this isn't a remand case. But in this, procedurally, the judge found that you didn't satisfy your burden at the first step. So when you said in argument a few minutes ago that the police didn't rebut it or the Commonwealth didn't rebut it, we never even got there, right? So why isn't this, I just want to be clear as to procedurally, would this be that we would find that perhaps you did satisfy your burden at step one and remand it for the Commonwealth to be able to adduce whatever evidence it could to rebut that?
I'd like to answer in two parts. First of all, the judge said, and even if you did raise the defendant did raise the inference, the Commonwealth basically rebutted it because he focused completely on whether there was evidence that
he knew,
the officer knew. So he actually does say that. But I will also say that this has a very unusual procedural posture because this court's procedure is that once an evidentiary hearing is granted based on the motion to suppress, it is, there's an inference that has been raised, and that was on the basis of the police reports that were consistent with what it turned out to be the police officer's intention here when use of the profile. So these police reports had indicated, although Lowell is approximately half white, no people were charged as a result of Snapchat monitoring who were white. They were all not white. So really what should have happened here is that the burden was on the Commonwealth to rebut the inference that had already been established. That was not complied with, really, the procedure.
Would you agree, though, that the Commonwealth, it would be open to the Commonwealth on step 2 to say the reason why we use these Bitmojis and the reason why we're looking at this group of people was because they're gang members who are responsible for an inordinate amount of crime and violence, which would be a legitimate use of monitoring, albeit based upon having a disparate effect on minority groups?
In this case, the police officer was clear. This was not based on suspicion of any activity, any criminal activity.
The hypothetical I'm raising to you, the question I want you to answer if you can, is a step 2 procedure to rebut the inference would include what I just described, correct?
The last few words, can you?
That would be sufficient to rebut the inference raised.
Would be, oh, that there, well, membership in.
I mean, when the FBI targets the mafia and the LCN and they look at Sicilian people, that's fine, right? Because it's a criminal group.
Well, it's.
Albeit directed towards one ethnicity.
The Commonwealth had an opportunity to rebut, and their rebuttal, apparently the argument is the officer didn't know and they relied on it.
You just won't answer my question about whether the police kid can do that?
I want to answer your question, I do. So I think, Dilworth, there was suspicion of gang activity. I don't think that's the end of the inquiry. They can certainly raise that.
Well, in Robinson Van Rader, what the trial judge found was, sure, you raise the inference, but the reason why you stopped the person was because of shots fired.
And the use of race or ethnicity in that kind of situation where there's been a description of someone who meets it, absolutely. There are reasons, yes, that can be certainly a reason to that in rebuttal.
So if we looked at what the police were doing in this case, were they targeting members of gangs in Lowell who are responsible for crimes? The use of Snapchat, albeit having disparate impact, would be legal, correct?
It may be given, I can't predict exactly how the evidence would come in, but it could be. I know there are challenges to the way that gang databases are established. I wouldn't want to suggest that someone couldn't raise that. That's not this case. This case, there's no suspicion of criminal activity.
If the officer on remand testifies, well, in Lowell, there are generally 2 kinds of gangs consisting of the following types of people: Asian people and Hispanic people. Would that rebut the inference raised by the defendant?
It would be hard pressed for me to believe that there are no gangs of white people. So
would that be necessary?
I think, I would like to know if they're only targeting Asians and Hispanics or blacks, if they're only targeting non-white people, I think that they would have to establish, and this really, I hope the court can somehow encourage these police departments to promulgate rules and regulations. I do want to answer your question, Judge Wetland. I'm not trying to avoid that.
Well, here's the question. If the officer on remand testifies, I created this Bitmoji of the non-white face and non-white name because I'm a member of the gang unit and we're interested in blending in with the gang members that we understand and know of consist primarily of Asian people and or Hispanic people. Would that be enough to rebut the inference of discrimination?
I would want to know, if I were the judge, whether there are other ethnicities involved in gang activity or people that are surveilled by the gang unit.
So your position is that the officers can't target a particular gang if they don't target white gangs?
Well, I think the inference would have been raised that this was intentionally discriminatory.
Right, so that's step 1. I'm on step 2.
Step 2, I think it really would depend on the facts. I think it's something that the court could consider, no doubt. I do want to answer your question, really. Can I talk briefly about the other, I don't want to kind of go off. I just really wanted to talk about the other issue as well. I'm almost out of time.
Go ahead.
Okay, this really is just like Donald. I have filed a supplemental, and so we're asking the court to allow Mr. Rodriguez's motion to dismiss and to vacate his convictions under 269, 10A and 10N. The firearms licensing scheme for residents that was in effect during this time period has the same deficiencies as the non-residents.
I wonder if it does, because at least in Donald, there was no standard. It was pure discretion on the colonel's part or the licensing authority's part. Here we have, as I understand it, at least a standard that the applicant is not a prohibited person. So why is
actually,
that?
Donald, they had the same restriction on the prohibited persons. This language is actually exactly the language that Bruin, the good reason language that Bruin threw out.
Well, the question, though, is whether 10A has any plainly legitimate sweep. And Bruin said you can't have, discretion in the issue, or it has to be a shall issue regime. Here, the licensing authority had no discretion to grant a license to someone who's a prohibited person. That is a category of persons with respect to which it was plainly legitimate to prosecute them. This can only be a facial challenge because there's no allegation that the defendant himself applied for a license. So why doesn't the facial challenge fail? Because there is a plainly legitimate sweep to 10A, namely the people who were prohibited people with respect to which the licensing authority had no discretion.
Just go back, so the actual licensing scheme is 141, it's, I'm sorry, chapter 140, 131D. And that is, that has the same prohibited persons language essentially as the Donald scheme.
But Donald didn't consider this question of it didn't talk about the prohibited persons and whether there was a plainly legitimate sweep.
Well, right, so the language in Donald, just like the language here, and I want to emphasize that this is pretty much exactly the language that Bruin objected to and found unconstitutional, this good reason language.
Was the applicant had been denied a license, right? It wasn't a facial challenge.
Bruin stated that this statute was unconstitutional.
Well, it
May
didn't
issue
address this statute, but it did address an as-applied challenge, right? In New York, the two gentlemen had applied for a license and had been denied.
Bruin has a footnote that lists the 6 regimes that of one, Massachusetts is one. And when you excise the good reason language that the court specifically objected to, you end up with a paragraph that deals with issuance of a license. How does someone get a license?
You end up with suitability. You end up with,
It's about,
right, so you end up with suitability in 131D. In 131F, the Bruin, as Justice Wendland points out, the language includes terms and conditions as may, it's a wild card, whatever the colonel wants to do.
Yes,
There's
so-
more discretion baked into 131F than there is 131D by the terms of statute, correct?
well, let me go back for 1 minute. The current paragraph of the 131D that allows for issuance of a license says may issue and includes the good reason language. The Commonwealth says, well, we know the good reason
I'm
language.
sorry, just
Okay.
to be clear.
Yeah.
By current, you mean the now existing or the?
No,
or the
no,
one
we're
under-
talking about, this was 2020.
Okay, you're talking about the
Where
Donald.
Statute is gone, it is passed.
Right.
And this, we are left, the good reason language that the court in Bruin said is not acceptable. You take it out, as the Commonwealth said, let's just take it out. It's not, and made a severability argument. Then you're left with a licensing authority may issue, unless someone's a prohibited person, which was also true with the Donald scheme. In terms of suitability, suitability is about denial. That suitability language also included the exercise of discretion, which was also objected to in Donald. So if you take out the good reason language that we know is bad. You have may issue a license. You essentially have a ban under Bruin, and there would be no way for anyone to get a license, and that would leave, that's completely rejected under the Second Amendment. So I would love to answer any more questions about this because it's really quite like Donald.
Does anyone
I would ask
have any other questions?
the court to grant the motion. Thank you.
Thank you. Okay, Attorney Staudinger.
Good morning, Your Honor, and may it please the court. Aaron Staudinger, Assistant District Attorney for Middlesex County on behalf of the Commonwealth. The Commonwealth is asking that this court affirm the lower court's denial of defendant's motion to suppress, where the where the motion judge properly found that the defendant had not raised an inference that the officer's actions were on the basis of the defendant's race, where the mere inference where the mere creation of a Bitmoji that depicted a non-white username or a non-white Bitmoji and non-white username is not enough to show that his
But that's
action.
not all the defendant put forward.
Yes, and it was,
Right, so here's an officer and he goes fishing, for lack of a better word, in a non-white Bitmoji, non-white name pool. And then he uses his fellow officers, who are also members of the gang unit in Lowell, to start developing a group of friends. And so the corner that he's walking is filled with non-white people. Why is that not an equal protection problem? Why doesn't it at least raise the inference necessary to meet the very low bar that a defendant now needs to meet under the totality of the circumstances test after long?
because in considering the totality of the circumstances, the judge was permitted to consider the other reasons, the other bases for the officer creating this.
All of the people for whom this social media network resulted in charges or police reports were non-white, right?
Correct.
All right,
And
so we have that also. So he goes fishing in a pool of non-white people, targeting non-white people, and the result is a non-white 100% capture rate.
And on the incident reports, I think it is worth emphasizing that Long is clear and Robinson Van Rader are clear that it has to be, that the relevance is the officer's past enforcement. And so here, the incident reports, I believe there were 7, only one of them was from this officer.
But isn't it relevant that all of his gang unit friends is his source of the network that he's building online?
It is relevant, but it is not enough.
No, but you're looking at it in isolation, and I thought the test under Long was a totality of the circumstances test.
Yes, and on that point, what I mean to say is that merely the creation of a situation, and we see this in, I know it was an unpublished case, but in the Hunt case and Stroman, and you see this in the context of jury selection, that merely the creation of a scenario in which the effect might be to target people is not enough to show that the officer's actions were on the basis of the defendant's race. And so, yes, it is.
But at the first stage of Long, why isn't it enough?
Because it still does not show enough that it was on the basis of that particularized defendant's race.
What would be, in the Commonwealth's estimation, enough to raise the low bar of showing a presumption of discriminatory selective enforcement?
I think in addition to, it is the Commonwealth's position that in addition to the creation of the Bitmoji, the non-white Bitmoji and username, there would have to be some sort of additional factors of the actual effect of this. It would,
So like all 100% of the people captured by this dragnet are non-white?
certainly not 100%, but it must be a percentage that's disproportionate.
No,
Something,
I'm taking the actual case here, 100%.
well, it's not 100% because as this court has been clear, you cannot just group and lump.
But isn't that the Commonwealth's fault? Did you produce the evidence of the particular race and identity names of the people being fished for?
I don't believe it is the Commonwealth's fault. It was a requested discovery by the defendant. The Commonwealth presented very compelling reasons as to why the Commonwealth did not wish to turn over the
But there are
discovery.
consequences to that, right? And one of the consequences is that the defendant is left with having to group anybody non-white together.
Yeah, and I do believe that the trial judge certainly considered that aspect. I think just given the small sample size of only 7 incident reports, only one of which the officer was involved in, it was certainly not improper for him to deny the motion to suppress.
Do we have a sense in the record of the friend group?
The record does not represent a friend group, and I do think...
Why is that?
Sorry?
Why is that?
Because that was the discovery request, was the Snapchat friend group by him. And I understand that point, and I think Dilworth makes clear that we are loosening the discovery rules on this for exactly this purpose, is you are starting to see, Dilworth certainly holds that there is a relevance to that group. I do think, however, it is important to note here that the defendant has, that the Snapchat group is not necessarily even from the relevant population. So the officer says, and his stated purpose is, that I was friending friends of people that the other gang unit's undercover accounts had been friends with. And so I started with that initial group.
But they're all friends of the undercover gang unit, correct?
The initial group that he starts with, yes.
Right.
And so
and then he wants to increase his numbers so he doesn't look like a bot. So he's trying to get a large number of friends, and he goes to the 7 members of the gang unit and says, hey, give me your list of friends that you're surveilling, and so I can increase my numbers. That's what we have, right?
Correct, at the
So they're all
outset.
targets of the gang unit, or surveilled people from the gang, of the gang unit, right? Doesn't that give us the plus factor to get to the totality of circumstances?
No, because thereafter his testimony was, and the record shows, that he then started friending, it was the friends of the friends, the 7 degrees of separation. As he starts adding people who those original group were friends with, he then starts adding people that those people then tagged in posts, and then the Snapchat algorithm itself, and this is also in the record, starts recommending people. And so what you end up with is this large spread of people that is not necessarily even in the low population of a particular protected class, or really with any sort of discernible features as to them. He is merely creating, like you said, the purpose of his friend group is to create.
What about the sword and shield conundrum? So you said for law enforcement reasons, you can't get that information. We don't want to tell you who the friend groups are to protect the confidentiality of these investigations. And then you come before us and say, well, it could have been a disparate group, so there's no discrimination. What do we make of that?
I think moving forward, it'll be less of a concern. I think Dilworth makes clear that this kind of information is going to be, at least under protective order or some sort of thing, we are going to start seeing the loosening. Of course, Dilworth does not hold that a defendant is entitled to it, where there is a compelling interest on the Commonwealth to maintain the confidentiality of those accounts. And I would not mean to suggest that this kind of discovery should be automatic. But I do think it's less of a concern here, because there's not even, the defendant couldn't even have made a showing that that particular friend group would be relevant. It would have to be some sort of aspect of the use of the, and like I said before.
Well, let's say the friend group consisted of only Hispanic and Asian and Black people. And then, you know, maybe some of them are not in Lowell. Maybe some of them are elsewhere. Wouldn't that be suggestive of a selective enforcement plan?
I think it would be suggestive, but not sufficient. And I do think
sufficient for the initial burden, even?
Yes, because I do think the initial burden in the totality of the circumstances, especially in the context of social media, this initial burden must consider the other reasons that the officer is using it. And they say in the social media context, because in the traffic enforcement you have a clear data point. You have the pulling over of the individual that is of a protected class, and so we use that as an action the police officer did. Here, the record is clear that he's not sending messages to anybody. He's not encouraging anybody to participate with him. He's kind of a fly on the wall in this situation, and so the judge was entitled at this initial stage to consider the reasons he was using this Snapchat. It wasn't because the defendant still has to make out that it was on the basis of his membership in a protected class, and so I think the judge is permitted to say, well, maybe he's friending people that he's just trying to do an efficient investigation of the population he serves. This is the same as an undercover officer, as was noted before.
Aren't you conflating this step 1 and step 2?
I do think that that evidence would be certainly relevant in the second stage, but I do still think it is or determinative in the second stage, but it is certainly relevant in the first stage, especially here when we have innumerable possibilities for the creation of the Snapchat. It could just be effective police work. It can just be serving the community. And so in that regard, the judge was entitled to say, yes, there was a creation of a Bitmoji that was non-white and a username that was non-white, but that is not enough, where there are all these other possibilities for the creation of that.
But that's not what the judge said.
Especially where, I was going to say, especially where he found that there was no way for the officer to have known this particular defendant's race. And I think that is key,
Would that make a difference? Would it make a difference if, because as I understand the record, this officer didn't remember how he had come to friend this particular defendant, right?
Correct, Your Honor.
Would it make a difference if this defendant was in the initial group of names that he had received from the other people in the gang unit, or if it was like a 7th generation out? Because it seems to me to say you don't know anything about, including the race of the person you friended, might be different depending on where the person was on that chain.
Correct. On that final point is that where it is, it might give weight to the fact that it was because of this individual's race. But I do think that it is important that the officer, the judge's findings that he could not have known this individual's race. And just because I think that weighs against this inference that the defendant is suggesting that the only reason he would create that Bitmoji was to target people of a particularized protected class, where he could not have known, where there is the anonymized nature of social media and the friend group he's creating, that weighed against this inference that the defendant argued, which was that the only reason he could have created this non-white Bitmoji and username was to target people of a certain protected class. And in this case, non-whites, because that was what the record was.
Was there any information in the record as to the composition of the people that the gang unit generally was monitoring?
On that particular question, no. There was the inference.
Wouldn't you need to have that?
Sorry, say.
Wouldn't you need to have that?
And I do think, going back to the original Justice Gaziano's point, is I do think that is information that the Commonwealth could introduce at the second stage to rebut this. Is these are the communities? Is information and evidence of these are the communities we are serving? This is the community we are trying to kind of keep a touch point on and obtain information on, and the Commonwealth could introduce that at the second stage to show, yes, there's a reason for the creation of a non-white Bitmoji and username that is race neutral. It is to create surveillance or monitoring in the community that we serve most predominantly. And so, yes, I do think that would be relevant on the second stage to rebut the inference that that it was motivated on the basis of race.
So why can't that use that exact same rationale to say that the inference was met at step 1?
I think you can.
Well, in this case, but you're saying, or at least you seem to suggest, that the trial judge was one of the factors to militate in favor of this was race neutral because you didn't know who you were targeting. But if you're getting your friend requests or you're extending your friend request to the friends of the other officers in the gang unit and you know who they're targeting, you may not know, but there's a reasonable probability that you're going to get folks that are non-white.
Yeah, and the Commonwealth does not mean to suggest that there's not an inference that people tend to be friends with people of the same sort of characteristics, but it is only that is not enough by itself. The creation of and you see this in the Supreme Court cases that kind of deal with this, and you see this is that it is the effect of a action does not necessarily mean that it is the intent of the action, which is why I do believe that more is required here than simply the creation of a characteristic Bitmoji, whatever it is, as long as it's a member of a protected class.
If we disagree with you and we conclude that the defendant's evidence at the motion to suppress was enough to meet the initial burden to raise a reasonable inference of discriminatory or selective enforcement, do we have to remand for the government to try to meet its burden at the second stage? Or is it enough, is the record what the government is going to produce, and we can just look at it ourselves?
The appropriate remedy would be a remand, Your Honor. I do think that from this record, it is clear that there was still a race-neutral reason. I don't mean to have my cake and eat it too, but I do think the appropriate remedy would be remand for further findings and further evidence as to the race-neutral purpose, and giving the Commonwealth the opportunity to rebut it. But again, I do think here that it is very clear that.
But wasn't your opportunity at the motion to suppress?
I don't believe so, because his finding, I believe he was holding a hearing to kind of delve into the reasons for the creation on the first prong. I certainly can't speak, and it's not on the record as to why.
So you think the judge thought, well, I know there's a motion to suppress, but I'm only going to deal with the first prong of Long?
Yes, Your Honor, and
I don't want to hear any evidence on the government's ability to overcome that presumption if made.
I can't necessarily speak for the judge. I think it.
Well, usually you don't have a motion to suppress hearing on a motion to suppress and only deal with one part of it.
Usually, in district court, I'd say sometimes that's not necessarily the case. But again,
It's not necessarily the case in constitutional issues where the defendant would have the burden. But you know in the Long framework that there's this initial burden and then there's a volley back to rebut that burden. This isn't just, hey, we want to suppress an ID or we want to suppress a confession. You know the framework.
Correct, Your Honor.
So why wouldn't we say that you had your opportunity when you knew that the judge was giving you, or at least was giving the defendant, a long hearing, that you knew that you would effectively have to adduce evidence to rebut the step one presumption?
And I think on that point, the Commonwealth has presented sufficient evidence to rebut the presumption of, and present a race-neutral reason for this. It is clear that he was friending members, that the other members of the gang unit, it is clear that it was in his community, or at least his intention was that it was in his community. The community he served was diverse. It was made up of a different makeup.
So then it doesn't need to go back.
I don't believe it needs to. I believe that would be the proper procedural posture. I understand that this hybrid evidentiary hearing where he took evidence and then found on the first prong is not ideal. It doesn't present a clean procedural posture for this court. I do think that you can affirm on anything apparent from the record, and it is clear here that the Commonwealth sufficiently presented a race-neutral reason for this action. And I would highlight, because I didn't in my brief, the fact that the officer testified that he wasn't sending messages to anybody, he wasn't inducing any sort of behavior. He was merely, as I said, kind of a fly on the wall observing posts that were made. And I think it is also important in that regard that he testified that he looked at every post that came in. This wasn't targeted. This wasn't on the basis of the defendant's race. It was merely a tool to create touch points and receive information. And I think that is a sufficient race-neutral reason.
Chief, can I ask about the second issue?
Yes.
If I could.
Yeah, just why is this case not Donald?
I think Marquis and Donald make very clear that this licensing regime stands distinct from the non-resident licensing regime addressed in Donald. There, as this court noted in Donald, the discretionary language on behalf for the colonel to grant a license was absolute. He could grant it if he wanted to, and under any conditions he wanted to. Here, the resident licensing scheme in effect at the time is readily severable. The provisions that Bruin called into question, the proper cause provisions, can be eliminated, leaving in effect a statute that reads may issue if not a prohibited person. As Marquis made clear, the may issue language itself does not doom a statute. It is the effect of the statute. I know it was only 3 states that kind of had this sort of effect, but if you remove out the good cause requirement and in 131d, it becomes a shall issue regime.
But isn't that also true in Donald, right? Like the colonel did not have discretion to give a 131F. They had 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 discretion to give a 131F. They license to an out-of-state, non-resident person who was a prohibited person, correct?
Yes, but I think you read it, I think Donald is sort of in reverse. I think they say you have absolute discretion to grant a license under whatever terms and conditions you want, but make sure it's not a prohibited person. So I think it was kind of because the discretionary language was so intertwined with the first act of giving the license, that is what sets Donald apart. Here you can take away that discretionary language of the proper cause requirement, and you're left with a may issue regime if not a prohibited person. It provides clear criteria for who a prohibited person is. We see in Rahimi that those kind of categories are upheld. They have a why and how in the analog in the history of the country's licensing scheme. And so I think you can readily sever that language and be left with a statute that would be licensing if not a prohibited person, which is a proper sweep of the statute.